Good afternoon, everyone. Welcome to today's webinar. My name is Amy Schwartz-Wallace. I am the Director of Training and Technical Assistance here at Empire Justice Center, and we wanted to welcome you to today's program. We are so pleased to have Joan Gerhardt from the New York State Coalition Against Domestic Violence with us again. Joan is the Director of Public Policy and Advocacy for the state coalition, and we'll be here to present the 2023 roundup of domestic violence legislation, a session review. So before we get started, I just wanted to alert folks there is a link at the top of the chat to the evaluation, and there'll also be a QR code at the end, so you can just hold your phone up and complete the evaluation nicely and easily at the end of today's program. You should have also received the materials today when you registered, and if you haven't, please check your email. I think those were sent out about 11:45-ish. And then finally, if you have any questions, I'll be monitoring the chat. So please be sure to ask any questions that you have there, and we will attend to them. You also can use the Q&A function if you wanted to ask something more anonymously, and I'll be checking both throughout the program. So with that, I will turn it over to Joan.
Thank you, Amy, and hello, everyone. Welcome. Good afternoon. So thrilled to be here again with the task force. I really love visiting with you once a year to run through the successes, accomplishments of the legislative session. So those of you who have participated in the past know that we usually cover a lot of information. So I apologize in advance for moving quickly, but my email will be at the end of these slides, which you will get a copy of. So if you have questions or want to get more information about any of the legislation that we discussed today, don't hesitate to reach out. I can always provide you with the text of the bill, more information. So please, you're not bothering me. That's my job. Please don't hesitate to reach out. So I'm hoping today to cover certainly the new laws, those that have already been signed into law by Governor Hochul. Those that were approved by the legislature as separate bills, as well as those that were included as Article 7s, as policy initiatives in the 2023-24 budget. Then we'll move to the bills that are still awaiting the governor's action. So these are bills that have passed both the Assembly and Senate, but have not yet been acted upon by Governor Hochul. And then, hoping there's time, I will give you a little snapshot into what I think Niskadev's priorities will be in 2024, and hopefully a focus of the legislature. And then we'll certainly leave some time at the end for questions and answers. But because we're going to be moving so quickly and covering a lot of legislation, please don't hesitate to put your questions in the chat as they occur to you, and I will try to address them before we move on to another bill. But if something occurs to you, no matter when, put it in the chat and we'll be sure to get to it at the end. And as Amy said, we are recording today's presentation. So both the recording and the slides will be available to all of the registrants. On each slide, I've tried to include either the area in the budget or the budget bill numbers, so you can pull up any legislation that you'd like to look at later. So starting again with the legislation that's already been signed into law, there were about 900 bills passed by both houses this year. That's about 100 less than last year, but that shouldn't be viewed as an unsuccessful session. In fact, 2022 was an outlier in that there were over 1,000 bills passed by both chambers. Usually what we see coming out of session is in the area of about 900. So they returned to, essentially an average level of achievement when you look at just bill passage. The governor has acted on about 43% of them, just under 400. So there's many more bills that she has yet to act upon. And the governor has until the end of the year to sign or veto bills. If she takes no action by December 31st, it is essentially a vetoed bill, and that's called a pocket veto. So I wanted to start today by reviewing the extension of expiration dates on three important statutory provisions. These provisions were initially signed into law years ago, and they had 2-year sunset provisions, meaning they expired after 2 years. But rather than let these laws expire, the legislature and governor have extended them every 2 years. So in this year's budget, we saw these same 3 provisions extended now until September 2025. So the first is the mandatory arrest law, which required an arrest when police have reasonable cause to believe a person has committed a specific crime against a family member or household member. So these are the family offenses. And this law also includes the requirement that police not ask if a victim wants to press charges. The second provision applies to children 14 years old and younger in a criminal proceeding and would allow them to testify with the use of closed circuit TV testimony. So in order to do that, there has to be clear and convincing evidence that the child will suffer severe emotional harm if they're required to testify without the use of the CCTV. And finally, the legislature and governor extended the maximum lengths for criminal orders of protection. So that's an 8-year duration for a felony conviction, 5 years for misdemeanors, and 2 years for offenses and violations. Now, you probably heard that in this year's session, there were some changes to the bail reform law that was initially enacted in 2019. It seems every year we've had some tweaks to either the bail reform or discovery laws. There's one aspect to the tweaks that were made in 2023 that's really important to our community that didn't get a lot of attention in the media coverage. So I wanted to be sure to elevate it for you. So back in 2019, with the initial law, individuals who were arrested under New York's mandatory arrest law could be issued appearance tickets. So that's like, you're driving and you get a driving ticket, same with an appearance ticket. It's just a piece of paper that you get and told when to appear in court at a later date. So police had the discretion to physically arrest when there was an alleged crime occurred, when an alleged crime happened between members of the same household or family, but they didn't often use that. What we heard from the field was that most domestic violence crimes, individuals who were arrested were only given appearance tickets and not brought to the police station for arraignment. Now in 2023, we've seen the legislature and governor change this. So police are now prohibited from issuing appearance tickets to those arrested under the mandatory arrest law. So we're hoping that this will now give domestic violence survivors more time to safety plan when a crime occurs. So looking at some of the other important bail reform changes that were made in 2023, I know there are some folks participating in today's webinar who know a lot more about bail reform changes than I do. So I'm going to do my best, but to keep it very, very high level. Essentially, I wanted to talk about the least restrictive standard change. So again, when the law was first enacted in 2019, judges were required to use a least restrictive standard when setting pretrial conditions that were necessary to reasonably assure the defendant's return for future court dates. Now this year, in the state budget, they replaced the least restrictive standard with language that actually looks more like language from before 2019. So judges are now required to base pretrial conditions on the kind and degree of control or restriction necessary to reasonably assure a defendant's return to court. Now, this seems a little vague. This language is a little vague. I do want to point out that the reason for setting conditions remains the same. It's focused on the defendant's return for future court dates. So there's no consideration of dangerousness or public safety. But the change in the language is vague, and I hear my phone buzzing here, excuse me. And we're unsure how it will actually be implemented. On the one hand, since judges can only set conditions that are the kind and degree of control or restriction necessary to assure someone's return to court, you might think that judges decide to have lesser restrictive conditions placed on defendants. So maybe they wouldn't be imposing bail or pretrial detention. But on the other hand, eliminating the least restrictive condition may influence some judges to impose harsher conditions, like including cash bail. So we're just going to have to see how this plays out. But it also does apply to all criminal offenses, so not just those that are bail eligible. Another tweak to the bail reform law was respect to some of the factors that judges can consider when setting bail. So back in 2019, judges could consider two important factors when setting bail in domestic violence cases. So only in domestic violence cases, judges could consider whether there was a history of gun use or possession or prior violations of orders of protection. Now in 2023, the governor and legislature approved the consideration of these two factors in all cases when setting bail. Now, these aren't the only two factors that judges can consider, but this was the tweak in 2023. And another change was that now judges can consider whether the charge allegedly caused serious harm to an individual or individuals. So that's a pretty significant change as well. If anyone's interested in looking at some of the additional reforms made to bail reform, I did circulate a great report from the Data Collaborative for Justice in the resources for today's webinar, and I encourage you to take a look at that. So one of the other policy initiatives that was in the state budget related to increased wages for attorneys and expert fees. So you likely already heard that wages for 18B attorneys increased from $75 to $158 an hour, which is really fantastic. But it also included expert witnesses in that as well. And two other important changes were that the legislature and governor upped the amount of maximum compensation permitted on an individual case to $10,000. So that's a pretty significant increase there, as well as increasing the maximum compensation permitted for expert or other service providers from $1,000 to $3,000. So now I'd like to talk about 4 laws that were signed into law in 2023, but that actually amend laws initially passed in 2022. So these are the result of negotiating that the governor undertook last year with the prime sponsors of legislation that passed in 2022 and got a negotiated agreement before she agreed to sign that bill into law. And so these are chapter amendments that were now enacted in 2023. So to walk through these, I'll first let you know what the 2022 law was, and then how the 2023 law amends what was approved last year. So the first applies to the new crime of unlawful dissemination of a personal image. So now in 2023, the legislature and governor ensured that this new crime applies to images posted on social media and those showing some degree of injury if a person posting an image participated in the underlying crime. So if I committed, God forbid, a murder and took pictures of it and then posted pictures of that murder, then I could be charged with this crime. Another change to the law from 2022 is that it clarifies that it doesn't apply to images that are of public interest, are newsworthy, or of artistic value. Now, this is a concern to us at Niskative because this is a very broad category of images that would not be included in this crime. I could probably make the case that almost any photo is of public interest, or is newsworthy, or is of artistic value, right? How subjective is that? So we're going to be watching pretty carefully how this particular crime unfolds, and if anyone is now charged with this caveat about these images that would not be included. The second addresses last year's law to create a statewide electronic tracking system for rape kit evidence that's collected to support a criminal investigation. Now, separate from this, you might recall that the state established a storage facility for materials collected from victims during rape kit exams when a criminal proceeding hasn't been initiated. So this 2023 law clarifies that the tracking system required by the 2022 law is for material that's been submitted to law enforcement to support a criminal proceeding, not the material that is stored before a criminal proceeding has been initiated. Now, obviously, this is very confusing, and I'm sure that there are survivors who will be confused as to where their materials end up. And we, along with NISCASA, our sister Sexual Assault Coalition, are working with DCJS and OVS to ensure victims understand where their materials are. Third, there was a law last year that permitted domestic violence victims to self-attest to their status to break bundled or family plan TV, phone, and utility contracts. In the final days of when this law was signed by the governor, we negotiated some additional protections for domestic violence victims to ensure that if abusers are seeking to obtain the accommodation for themselves, that domestic violence survivors are protected. Unfortunately, there was agreement that these protections needed to be amended, essentially a chapter amendment into the 2022 law, but the bill to implement them didn't pass the legislature in 2023, which was very disappointing for us. So I'm sure this is going to be a top priority for Niskative in 2024. Excuse me. And finally, last year, there was a groundbreaking law to mandate domestic violence and child abuse training for forensic child custody evaluators. There were some tweaks to that law that were enacted this year. Essentially, children who are living outside of New York and more than 100 miles from the New York State border can now be interviewed by trained forensic evaluators remotely, so they don't have to come back into the state. And it clarifies that OPDV and Niskative will be mutually responsible for developing and providing that training. And we are now doing that. The training is being developed right now. So I see a question, who's doing the domestic violence and child abuse training for forensics? That will be developed and provided by OPDV and Niskative jointly. OPDV being the state agency for the Office for the Prevention of Domestic Violence. So now moving on to the Equality Amendment, you likely already heard about this because it did pass last year in the 2022 session, as well as this year. Currently, our state constitution only prohibits discrimination based on a person's race or religion. This amendment will expand the discrimination provisions by adding ethnicity, national origin, age, disability, and sex, including sexual orientation, gender identity, gender expression, pregnancy, and pregnancy outcomes. And the amendment would also protect against any government actions that essentially prevents a person's reproductive autonomy or their access to reproductive health care. So now that the amendment passed both legislatures, it will appear as a ballot initiative in 2024. We also saw enacted the Wage Theft Accountability Act. Now, wage theft is when an employer doesn't give an employee what they owe them. So that could be a failure to pay overtime, failure to give them access to meals or rest breaks, the right to be compensated when injured, or maybe not getting reimbursed for items that you purchase for work, such as a uniform. And I was surprised to learn that each year, $3.2 billion in wages are stolen from approximately 2 million New Yorkers. And of course, this is a serious form of worker exploitation and certainly impacts vulnerable workers, including undocumented immigrants and low-income workers. So this new law makes wage theft a form of larceny, which allows prosecutors to seek stronger criminal penalties against employers who engage in this kind of conduct. There was a package of bills relating to reproductive health. This is a continuation of a broader package that was done back in 2022. The 4 bills that have already been enacted into law, the first enhances legal protections against the arrest and extradition of abortion service providers. And this law also prohibits cooperation with out-of-state investigations related to the performance or aiding in the performance of abortions performed in New York. The second allows hormonal contraception to be available over the counter at pharmacies. And this authorizes licensed doctors and nurse practitioners to prescribe essentially generic orders to pharmacists to dispense the drugs. And then pharmacists can do that if they provide patients with a self-screening risk assessment and a fact sheet. We now have access to medication abortion drugs at all SUNY and CUNY campuses. The schools can either employ authorized prescribers or provide referrals to authorized prescribers. And finally, a new law protects healthcare providers who offer reproductive health services via telehealth. And this also prevents these healthcare providers from professional disciplinary action for any legally protected activity.
Joan, we had a question back on the wage theft, and I'm not sure if you know this or not. For the new law making wage theft a form of larceny, do we know if this is the first of its kind? The person asking said they haven't heard of any other state laws doing this, and they think it's a long time coming.
Oh, well, that's good news.
Yeah.
I don't know. I don't recall hearing, through our network of public policy directors in DV coalitions nationally. I haven't heard of any other states that have implemented that, but I haven't actually researched that. So I can't say for sure.
Thanks,
Thank
Joan.
you for the question.
Yeah.
So there's also a package already enacted into law that address LGBTQ plus related issues. The first 2 laws require the use of gender neutral terms, both in state law and on state websites. So that prohibits the use of terms like husband, wife, fireman, policeman, but it doesn't apply on websites that address a gender specific matter like pregnancy. We have the New York State Safe Haven for Trans Youth and Families Act now signed into law. This is a tremendous piece of legislation which prohibits courts from considering a finding of abuse based on a parent allowing a child to seek or receive gender affirming care. It also prohibits law enforcement cooperation with other states regarding lawful gender affirming care performed in New York State, and prohibits courts in New York from executing out-of-state subpoenas related to gender affirming care. So a very comprehensive piece of legislation there. And finally, we have updated the definition of sexual orientation in the human rights law. This removed an outdated disclaimer against illegal conduct, which was really code for homosexuality. So it connected homosexuality to illegality in statute. So this updated definition removes that. And then a couple of things I wanted to mention on public benefits. The first is another 2-year extender. We talked about 2-year extenders at the beginning of the presentation. This one was not part of the state budget, so it has a slightly different time frame, which is why I chose to talk about it separately. This one extends the income and resources exemptions for public assistance applicants. So now, again, a 2-year extender. These exemptions are set to expire in August 2025. And this ensures that recipients of public assistance don't have to bankrupt themselves in order to receive those benefits. And it includes liquid resources, a home, a car, a burial plot, money set aside for funeral arrangements, etc. Now, we've been working with Senator Persaud's office, the chair of the Social Services Committee, on taking a look at all of the exemptions and requirements for recipients of public assistance. We still think that they're way too strict and hope to continue working with her office and others as we go into 2024. There was in the state budget in Article 7 that was approved to increase access to education and training for recipients of public assistance. So this removed the 20-hour work requirement for those who are attending a post-secondary education for more than 1 year. It also permits vocational training and, really importantly, permits a one-time disregard for all earned income following job entry for 6 months. So that's really wonderful news. And another Article 7 relates to skimming. Skimming is when bad actors install devices at point-of-sale terminals like gas pumps to steal card data and drain recipients' accounts of benefits. And this is actually on the rise in New York State. I was again shocked by these numbers. From October last year to March of 2023, over $1 million in cash public assistance was stolen from more than 4,000 households. And it's even more significant for SNAP benefits. There was 6.3 million in SNAP stolen from more than 7,000 households. So this is a big problem for us here in New York. So this would require county DSSs, Departments of Social Services, to reimburse victims of this type of fraud within 5 days after verifying that the benefits or property had been stolen. And the newest law we have, this was just signed by the governor last week, relates to fees for applying for an extreme risk protection order, or an ERPO. So the ERPO law was enacted in 2019. It's been tweaked since then, really to increase the number of people, the type of people who could apply for ERPOs. ERPOs essentially prevent individuals who show signs of being a threat to themselves or others from purchasing or possessing firearms. And just as a reminder, ERPO applications can be filed by police, district attorneys, school officials, healthcare professionals, or members of a person's family or household. So now anyone who wants to apply for an ERPO doesn't have to pay an index for that file, that application, to get an index number fee, which is typically about $215. So now there'd be no financial barrier to applying for an ERPO. So I think those are all of the laws that I wanted to cover before I move on to those that are awaiting the governor's action. Amy, is there anything else in the chat or Q&A I should be addressing?
There is not. So
Great.
Please move on.
Okay. So I did try to bundle some of the information about courts at the front end of this section, knowing the audience today. And Amy, this is a bill I think you know a lot more about than I do, but I did want to include it. It's really, really important, which allows any person in civil court to submit an affirmation under penalty of perjury rather than a notarized affidavit. So this is for both litigants and non-party witnesses in civil court. And we know how burdensome it's been to get a notarized affidavit. And federal law has removed, excuse me, this requirement decades ago. And even in New York, attorneys, physicians, and dentists have already been exempt from this requirement. So we're really hoping that the governor sees fit to sign this into law and make it easier for everyone to participate in civil court proceedings. There's also a bill that passed both chambers to increase the number of judges in certain courts. I've listed them out there for you. Additional Supreme Court justices in 3 different districts, multiple judges in New York City's family, criminal, and civil courts, and new family court judges in 10 counties in upstate New York, if we call Westchester upstate. I'm still not of that ilk. There is a really important bill that we hope the governor signs, which would extend due process protections to applicants who are seeking post-conviction relief. And this would include giving them the right to access complete discovery and to retest physical evidence. Now, this follows a 2018 Court of Appeals ruling that people who plead guilty can't challenge their convictions on grounds of actual innocence unless they have DNA evidence supporting their claim. So this bill would allow them to obtain that DNA evidence and have the opportunity for a meaningful review of their case. The second bill follows changes made in 1996, if you can believe it, that long ago, by Congress to federal immigration law, which now essentially allows legal immigrants and residents to be subject to automatic removal from the country if they plead guilty to minor offenses such as violations. So the Assembly and Senate passed a bill that would require notice to these defendants that they could risk deportation or denial of their citizenship if they're not a citizen, and choose to plead guilty to a misdemeanor or violation. And finally, on our courts roundup relating to the current definition of rape, New York has an extremely limited definition, which applies only to penetration of the vagina with a penis. So men and trans women have categorically been excluded from being victims of rape. This bill would remove the penetration requirement from our rape statutes and redefine rape to include oral and anal sexual conduct, recognizing that other forms of forced penetration or sexual contact can be equally painful and traumatic. Now moving on to the Clean Slate Act. This is a bill that passed in literally the final hours of session, and it did get a lot of media coverage, which you may have seen. The Clean Slate Act would automatically seal criminal convictions after 3 years for misdemeanors and 8 years for felonies. So this would happen automatically. There'd be no action needed on the part of the defendant. And this would be done automatically, assuming that the defendant completed their sentence, parole or probation, and didn't commit a subsequent crime in that 3 or 8 year period. So that's important to know. So if they do commit a subsequent crime within 3 or 8 years, then their records would not be sealed. There's also a carve out for sex offenses. So there'd be no sealing of records related to sex offenses, but it doesn't include family offenses. So convictions related to family offenses would be sealed either 5 years after a misdemeanor conviction or 8 years for a felony. Now, due to some negotiating that advocates did with the legislature and governor's office, there was an additional provision added into the last version of the bill, which states that the sealing of records would not affect or invalidate active orders of protection. That's good, but we don't think it goes nearly far enough, and I will get to that in one moment. There's also a provision in the bill which would create a cause of action for damages against anyone who discloses a sealed conviction or information about that conviction without the consent of the defendant. So I want to be very clear that the Clean Slate Act would seal records, not expunge them. And this is an important distinction because some entities are identified in the legislation to be able to request access to the sealed records. So if they were expunged, they wouldn't exist anymore. In New York, we're talking about sealing them. And there are a number of individuals and entities who would still have access to the sealed records. This is not an exhaustive list. This is just the entities I thought were most pertinent to our discussion today. So defendants and counsel, any court, defense counsel, or prosecutor for a pending criminal proceeding, or defendants who are undergoing their own criminal case where sealed records from someone else's record would be integral to their defense. Qualified agencies, which are defined in statute and includes law enforcement, probation, sheriffs, DAs, docs, and CPS. These next two I underlined because these were really important to us at Niskative, and I wanted to make sure to elevate them. The first one relates to civil court proceedings, particularly family court. So if the defendant becomes a witness or a party in a civil case, such as a child custody case, then the court and the parties to that proceeding can request access to the sealed records, as well as if the defendant becomes a witness in a criminal case. Also, those who are seeking to avail themselves of a public program or benefit, such as an individual looking to obtain a U visa, they can still apply to have access to the sealed records. Entities who are performing fingerprint-based criminal history checks, and those who employ police officers or who issue gun licenses. So the process for applications to request access to sealed records would be under DCJS. DCJS will develop the form and the process. There is no time frame for which these individuals would get access to the sealed records. So that's actually one of the recommendations that we've made to the governor for a chapter amendment consideration, was that we should add a time frame. So if someone's in a civil court proceeding and requesting access to someone else's sealed criminal records, that civil court proceeding isn't held up because DCJS is taking months to respond to the request. We also thought it was really, yeah.
Sorry, Joan.
Yeah.
To that point, can somebody plead that there are priors in for example, like a custody petition without access to the sealed records, without violating the law, or do they have to request the sealed records in order to make the disclosure that there are priors?
I am not an attorney, but my interpretation of the bill, I want to come back to this point here, this final bullet about a cause of action for damages if someone discloses information about sealed records without the defendant's consent. So I think there's some interpretation there that needs to happen, but I would be concerned about a party doing that without having approved access to the sealed record.
Thanks, Joan.
Sure. So I did want to mention one other chapter amendment recommendation we've made to the governor, is that individuals who are either designated as an offender or a respondent on a valid criminal or civil order of protection should not have their records sealed. And we have a lot of reasoning for this that we probably don't have time to go into today, but a lot of it revolves around the timeframes for orders of protection, which in severe cases can be 5 years for misdemeanor convictions or 8 years for felony convictions. So here the sealing of records for felonies does match 8 years, but we're talking about sealing misdemeanor records after 3 years. So it is very possible that someone could have a valid order of protection where the underlying misdemeanor conviction has been sealed. And we think that will be very problematic for law enforcement, as well as for survivors having to defend valid orders of protection. So I'm sure more to come on that. The governor has not indicated whether she will sign the Clean Slate Act as is or is looking for some chapter amendments, but we continue to reach out to her office on that. And I encourage anyone listening today, if you have concerns or would like to support that view, please communicate with the governor's office. So now moving on, frankly, to another complicated bill, which hasn't gotten a lot of attention and might surprise you to learn that both the Assembly and Senate have passed this bill. So again, it is not law, it's waiting for the governor's action. This relates to visitation after a parent's termination of rights. So essentially what this bill would require a family court to order upon an individual's request, post-termination visitation between the child and the biological parent after a termination of that parent's parental rights. Now, it is subject to the best interests of the child. So I'm going to tell you what the bill memo says about this bill. Current law in New York provides for open adoption and post-termination visitation and/or contact when a parent voluntarily surrenders their parental rights. But it doesn't give the courts any authority to allow for that contact or visitation after a parent's rights have been terminated by the court. So New York State judges in the second and fourth appellate divisions for years were authorized by case law to order post-termination contact, but that changed in 2012 after the Court of Appeals ruled that judges didn't have the explicit authority to grant post-termination contact. So currently, parents who do not surrender their parental rights risk losing all contact with their children if they choose to defend their rights in a termination of parental rights proceeding and lose. So this bill seeks to equate the voluntary surrender of parental rights with an involuntary termination by the courts. So the court, if it does issue post-termination visitation, the court would determine the type of contact, whether it's supervised visitation, calls, emails, letters. The only way the court could do it is if all parties consent. If they don't consent, then the court must first hold a hearing to determine if the visitation is in the child's best interest. And the burden of proof then falls on the parent applying for the visitation and has to establish that any party opposed lacks a reasonable basis. And there is no visitation permitted if a child is 14 or older and doesn't consent to the visitation, or if a parent severely or repeatedly abused the child. And I put that in quotes because that's not a provision that I'm familiar with in statute, that phraseology. So, and it hasn't been defined in this bill. So that's a new statutory requirement. So very complicated. I'd frankly be interested offline. If anyone has thoughts on this bill, please reach out. I'd love to talk to you more about that. Now, we worked very hard in coalition with other victim service providers and advocacy groups on the Fair Access to Victim Compensation Bill. This was one of our priorities. Of course, we know financial compensation after crimes gives victims increased stability. It covers their costs, hospital bills, mental health counseling, lock replacement, replaces personal property. But in New York State, to be eligible to receive victim compensation, victims have to report the crime to law enforcement within 1 year of the crime occurring. Now, for a variety of reasons, including fear of retaliation or blame, stigma, shame, or mistrust in law enforcement, victims may wait to report or choose never to report. So we thought increasing eligibility was really a requirement in New York. This would ensure that victims are eligible to apply, regardless of whether an individual has been charged, arrested, apprehended, or prosecuted. And it also no longer requires victims to report crimes to police. Individuals who want to report the crime to police still can. So that avenue still exists, but there's now an alternative avenue where victims can get a third-party attestation by a licensed victim services provider, either licensed by New York State or New York City, to support the claim. It also would expand the time frame for reporting the crime to police from 1 year to a reasonable amount of time, and would expand the time frame for filing claims from 1 year to 3 years. Another bill we're excited about is a bill to create hope cards. Currently, when the court issues an order of protection for a victim, the victim receives a paper copy of the order and is instructed to carry it with them at all times. And the order contains all the relevant information needed by the victim to ensure the order is fully enforced. Now, this can be multiple pieces of paper, which is cumbersome to carry around. They get torn or folded up and ripped. Now, victims, of course, can request new copies, but that takes time to receive. And we're actually hearing from victims that they're waiting months to receive copies of their orders of protection, or are being required to go to law enforcement records rooms to get copies. So a hope card is a wallet-sized laminated card that contains the pertinent information regarding final orders of protection. So this does not address temporary orders of protection, only final. And the bill would essentially require the Office of Court Administration to develop the program and make these hope cards available to victims who request them. They'd be free of charge, and victims could receive as many cards as they wanted. And the cards would have the same effect of the paper orders issued by the courts. Now, we think that, if the governor sees fit to sign this into law and victims start receiving these cards, it is likely we'll have to do some training with law enforcement so they understand that these cards are the same essentially effect of the paper orders. I can see some trouble in the field with that. So that would be something we work on if this is signed into law. And there's a bill that would require the State Office for the Prevention of Domestic Violence to create informational materials on economic abuse. These materials would describe the impact, how to identify economic abuse, prevent it. It would include information on coerced debt. There's a really great bill that addresses coerced debt, I'll talk about in a minute, as long as, in addition to resources available to victims. And these materials would be available at local domestic violence shelters, county offices, police departments, and child care facilities. I'm going to start to speed up because I see we have 10 minutes left. There's another bill that would create a task force on missing women and girls who are Black, Indigenous, and people of color. There are thousands of missing Black and Native American women and girls across the country. People who have been abducted, sex trafficking victims, runaways, and of course, these cases don't receive a lot of attention. So this task force would be made up of the various state agencies, state police, would include directly impacted individuals, and would identify policy changes that would address the lack of care and concern for these individuals in governmental agencies. Some other additional bills you might be interested in. There's a bill that would designate athletic trainers as mandated reporters. There's a bill that would prohibit sexual harassment victims from paying damages for violating non-disclosure agreements. That's a great bill. Another great bill is making sure that individuals who are released from jail understand their right to vote. Most individuals do have a right to vote, but there is confusion, particularly for people who have been convicted of crime and even incarcerated. So this would clarify that individual either does or does not have the right to vote and give them information on how to go about registering. Still some more work to do with reproductive health services. There's been some hospital mergers that haven't considered the impact on reproductive health services. That's actually going on right now in the Albany region. So this would require consideration of those impacts before a hospital closure or merger is approved. Some work on human trafficking. There was several laws passed last year on the posting of human trafficking information in public spaces. This is a continuation of those laws. Now, if signed into law, would require posting of that information in various lactation rooms around the state, Port Authority airports, bus terminals, transit facilities, truck stops, if they have lactation rooms, and commercial airports. A bill to extend the human trafficking task force for 4 more years. Another bill that would investigate connections between social media and human trafficking. We know that traffickers use social media to lure victims. So it's really important to understand those connections so we can prevent trafficking proactively. And there's also a great bill that would create the New York State Community Commission on Reparations Remedies. This is a fascinating bill. I encourage anyone interested to take a look at it, particularly the bill memo, which goes through a very methodical history of slavery, both in the country and in New York specifically. So very informative. I learned a lot. So I know we only have a few minutes left. I am going to do a forward-looking view for 2024. Amy, anything? I know there was some discussion about the Clean Slate Act. Anything I need to address before we move on?
Well, I think, the discussion was really around, the impact of clean slate when people are seeking orders of protection or custody, or frankly, I guess, on some of the occasions where they might be talking about divorce grounds. But I think, a lot of the concerns are around, the ability to raise the prior convictions in these civil proceedings. Even with the carve out, I think there is significant confusion, and it's going to hamstring domestic violence survivors from talking about the things that actually happened to them with the same abuser. So who may in fact have ongoing proceedings in any number of venues. And I think, at least for me, the red flag is raised where the abuser would have a cause of action against someone for raising those things. And I could see, that certainly being utilized as a tool for retaliation or further abuse if the victim were to talk about the priors that the abuser has. So, I think there's a lot of concerns. I know Niskative has worked on trying to fix some of these concerns when the bill was being negotiated originally, as well as now. And I don't know if you're this is recorded and getting posted, so it's probably not a great place to discuss sort of next steps. But if Niskative is continuing to work on those issues, it might be helpful just to share that with the group.
Sure. Yeah, I mean, we did send a letter to the governor that discussed some of our recommendations. As I said in the presentation, I'm happy to share that letter and talk more to anyone who's got more questions or seeking more information about the bill. But it did pass in such a flurry. It's kind of interesting, of all the criminal justice reforms that we were focused on, that's the one that we heard they're far apart. It's never going to pass. And then it literally squeaked through in the final days of session. And it really was like, trying to stop a moving train. So, but I do think that the governor and legislature want to get this right, which I think is really important. So if there are things we want to communicate, we really should do it and do it now. So with that, let me move on. I've got 4 minutes. Let me run through this very quickly. I think those of you who are familiar with NISCATIV know that we have been prioritizing improvements to family court for domestic violence survivors. We have a package of legislation that we've been working on. Top of the list is Kira's Law, which would prioritize the safety and well-being of children during child custody and visitation proceedings. We'd also like to get looking again at supervised visitation. There was a great report, which I included in the resources for today's webinar, that was developed by a group of advocates along with OCA to really audit supervised visitation programs across the state. Really informative. There's the bill that would essentially enhance due process rights of domestic violence victims by giving access to child custody evaluator reports. There's also a bill to, eliminate forensic evaluators. And now forensic evaluators are going to be trained. As you know, NISCATIV is involved in doing that training. So I think the legislature and governor chose to go that route rather than eliminating forensic evaluators. But it is something that we're keeping on our list to see how the training really changes things, if it does change anything in our courts. There's a bill to prohibit forensic evaluators from appearing as expert witnesses. We think that's a conflict, as well as eliminating their quasi-immunity. Forensic evaluators are the only court personnel who have immunity, and that just doesn't seem to be the right way to go to keep them accountable. Some other bills that we're looking at, I did mention coerced debt. This is a great bill introduced by Assemblywoman Rosenthal, which would ensure that victims aren't held liable for coerced debt. So this would require creditors to cease collection activities and stop reporting the debt to credit reporting agencies if, upon investigation, they find that the debt is coerced. There's a bill to move away from anonymous CPS reports to confidential reports. We know that abusers routinely use anonymous reporting to harass domestic violence victims and their children. And this takes time away that the state agency, OCFS, has to spend on these cases rather than families who really need support. So confidential reporting involves the use of identification numbers. We'd still know who's making reports, but they would no longer be anonymous. So no one could just call and hang up the phone and say, thank you very much. Making sure that domestic violence service providers are paid equally when they house either families or single adults in shelter. There's currently a pay differential for that. We'd like to get back to the comprehensive sex education in schools bill, more work on shelter allowances and public assistance, as well as getting back to those additional protections for domestic violence survivors who are seeking to break phone contracts and utility contracts. And then, I think that we, along with other coalitions like NISCASA and the New York State Children's Alliance, are working really hard to stabilize funding for victim services. There's actually going to be a Senate public hearing on domestic violence funding on October 3rd. That was just announced yesterday, as well as COLAs, increased wages, contract reform, and increased public benefits, particularly in housing. So we have a lot of work in front of us. So I know we're really at our time. I know people have asked questions throughout. Is there anything, Amy, pressing before I put up the save the dates?
No, Joan, but if you could put up the QR code on the next, or in the next couple slides.
I will. So just wanted to, this is in your slide, so you don't have to jot it down, but we do have our dates for advocacy days next year, February 28th, Budget Advocacy Day, and our Legislative Day of Action, April 30th. And here's that QR code. So please let us know how you enjoyed today's webinar. We're so happy that you were here, and I do apologize for packing so much into this presentation and talking so fast.
I just wanted to thank Joan. This was, as always, an excellent presentation, and we always get Joan fan emails afterwards. So thank you so much, Joan, for the program. Yes, once again, another awesome summary that spans, many different areas of law. So thank you so much, not only for spending all the time collecting this, but also reporting out on what it means for domestic violence survivors, because domestic violence intersects with so many areas of law. So thank you.
Sure. And I'm happy to hang on for a minute or two if someone does post something in the chat.
Great, thank you. And the QR code, again, for folks, you can just put your phone up. You're probably really familiar, or looking at QR codes now during the pandemic, but we want to hear from you on how today's program was for you. So if you could please use the QR code and just take a quick evaluation survey, we would really appreciate it. So we'll just hang out for another minute if there's any questions, but I'm not seeing any, Joan, other than big thank yous. All right. Well, with that, we'll thank you all for coming. Thank you for those of you that joined early and stayed late, and have a wonderful day. Thank you. Thank you to Niskadev for joining us today. Bye-bye, everyone.